We have laws, but they are like a volcano which has become dormant over a span of time. And government, in my view, is going out of the way to help the builders. If I told you that in some schemes in Bombay, the FSI for builders is 15, would you believe it? In fact, at some places, builders are not even able to utilize those FSI because of lack of open space and the size of the plot. These are things which are hidden by the builder from the flat purchaser. Bulk of the schemes of redevelopment are under various clauses of the redevelopment, 33.5, 33.7, 33.9, 33.11. And what they do, builders amalgamate plots. For example, today I have got plot A, plot B, plot C. In order to avail extra FSI, they show that this particular property is being amalgamated and this property is going for redevelopment. Bulk of the schemes of the builders are under different clauses of the MADA and BMC laws, where the intention is to maximize on the FSI. Has it ever occurred to you that is the builder complying with the laws of the land? Our PMC, whom many times I humorously call Pura Malai Kamalo, they always say, yes, everything is complied, you are not to worry, builder has taken care of everything. I ask one developer in the galaxy of developers in Mumbai, have they ever paid stamp duty on the amalgamations of plots? What happens is, there is plot A, plot B, plot C, etc. and all these plots are combined. If say my flat today is in plot A, I may be eligible to get a flat at a place on which plot C is there, societies by a different name is existing. Because we are merging all the societies, dissolving all the society and fresh new societies are being formed. My personal view is, as per section 3 of the Maharashtra Stamp Act, it is the instrument which is liable for tax. And the document that is being executed as regards amalgamation, there won't be any written document being done by the builder because they take a shelter that we are not executing instrument, so we are not liable for stamp duty. But the order being passed for amalgamation by the government official city survey office, that is also an instrument within the meaning of the Maharashtra Stamp Act, and that attracts stamp duty, is my personal view. Time and again we are writing letters to the IGR office, and as usual, when tricky questions are asked, bureaucrats never reply. Let me slightly drift from the point. From 1947 to 2024, almost so many years have passed. Government has not been able to enforce conveyance in favor of legal entity. Why cannot a simple thing like conveyance be obtained in a short span of time of 4 months, 5 months, 6 months? Why? If you have the will, in 1 hour they can implement all these things rather than going this. They have to make offenses by builders, non-bailable offenses. And second thing, unless he executes the conveyance, he should not be given a right to sell 10% of the property. Unless he obtains building completion certificate and conveyance is given to the society, he should not be allowed to do these things. Are you aware of the fact that MOFA Act says that if a criminal prosecution is initiated against the builder and if he is found guilty, he cannot commence construction activities in the state for a stipulated period of time of 3 years to 5 years. But all these things are very rosily written on a piece of paper. For not forming a society, there is the judgment of Torna Cooperative Housing Society for which builder was prosecuted and sent to jail. For not obtaining occupation certificate, there is a judgment of Prerna Cooperative Housing Society in Metro. Both these judgments are of Metropolitan Magistrates Court, and the builder was sent to jail. We have laws, but they are like a volcano which has become dormant over a span of time. And government, in my view, is going out of the way to help the builders. There was one circular issued by the police authorities to make all these offences cognizable, and immediately, in a very short span of time of few days, that circular was withdrawn. 4 months time limit is for getting conveyance and registering the document. We have got orders that after 4 months, whatever is the excess stamp duty to be paid, that has to be recovered from the builder. But how many people are aware of such things? Are you aware that registration fee today is capped at 30,000? But in between there is a proposal to increase registration fee to 1% of the market value of property, and after a few days at lightning speed, that circular stay was given to that particular order. So the cloud which adversely affects the builders, somehow or other it remains like a dormant volcano. It remains on paper somewhere, some corner. I have no hesitation in saying that in my so many years of practice, I have not seen a single agreement complying with the laws of the land of MOFA, model agreement. Form 5 model agreement is very much crystal clear that you have to mention what is the FSI for the plot of land which is being developed by the builder, for the property being developed by the builder. And rarely any builder dares to write these things. You look back across decades, the agreements. Earlier, no builder was writing the area. Earlier, builders were selling car parking. Even today, many builders are selling car parking, which everyone knows is illegal, bad in law. In fact, I will say, reputed industrialists like Adi Godrej, Sessions Court had given directions on a simple application of one Mr. Shetty to criminally prosecute such an eminent industrialist of India. Of course, he went to High Court and has taken a stay. That is a different thing. But when Metropolitan Magistrate did not take action, Session Court in black and white has passed orders, which I will share it with Moneylife, and you can take, anyone can take it from Moneylife, this judgment. The point I am trying to make is very simple for you. As a flat purchaser, you have to be vigilant. Don't depend on your secretary. Many times they are bought over. They are refined estate agents. It is not that for money they are doing it. They don't know emotionally how builders take them in their clutches. They talk sweetly with them. The only qualification to be a builder is a sweet tongue and a smiling face. He will just say, once you give me possession of the property, then I will show you what I am. Till that time, his approach is different, and the day you give him the possession, the approach is different. Now coming back to the redevelopment point, you should not trust your managing committee members, golden rule. Builder is a visiting faculty in the life of the building. His relationship with you, his marriage with you is just for 3 years, 4 years if he is a good builder. Otherwise, like a notorious daughter-in-law, 24/7 you are bound to get harassment from him. When it comes to redevelopment, you should know how to emotionally blackmail the builder. Let me give this example. Whenever your negotiations are taking place with the builder, some talkative lady should take a lead and say, what do gents know? They are not staying in the house. They are just going for office or service whole day. It is we who are staying here, and we will not accept one thing from you. We want one thing, a firm commitment from you, that above our toilet, we should have sufficient space to keep our goods. The idea behind this is normal. A person's height, 6 feet, we can presume, because he has to raise hand, 6 feet, 6.5 feet. And above that, if you ask for storage, you will automatically have the height of the room will be increased. Height is not measured, the area is not measured just in length and breadth. The height also has a different impact. You look at the houses some 4 decades or 5 decades ago. We had a door, and above that there was a ventilation. Now, in most of the 99% of the new buildings, you won't see any ventilation above the door, because the height has been reduced, and builders calculate the height floor to floor and slab to slab. Even that half-inch thickness they take into consideration. So the point I am trying to make is, in redevelopment, you should have multiple committees. One of the committees in which ladies should take a lead while negotiating. At the time of negotiations with the builders, one team will irritate the builder by asking nasty questions. And after that, other team members will come into picture and they can, nahi, uska to aadat hi aise hi bolne ka. You don't take it into serious. We have to be like politicians and play our cards properly. The best way to learn in a redevelopment proposal is from the builder who are coming to give you an offer. You should have a scrutiny of, say, from 10 builders, you first shortlist 5 builders. And how to play that. Today, we are seeing the elections and the announcement will come in a short span of time from now. Now, one builder is coming. One team of us will try and talk in favor of that particular team. And we as a society should have this understanding. On that particular day, when builder A is coming, one of our team which is going to be favorite of builder A, everyone has to give importance to that that team, let's call him team 1. Say that team is supporting BBJP. So that everyone on that day will talk in terms in favor of team 1. The impression that will be created is team 1 is very powerful and what they take a call, that is final. The moment this first builder exits, builder B comes, and at that time we have team 2. That team 2, let us call it Congress. So that on that particular team B, team 2, on that day we have to give importance exclusively by all members in favor of team 2. So that team 2 will try and this thing, give importance. In that way we are confusing the builders who is having hold in the building, because many times we have seen builders manage the committee members. In one instance I was told the committee members were taken to Bangkok and they had a very good time. Somehow the relations, this was at Khar which had happened, and somehow the relations with the committee and the builder got strained. When the other members went to the builder, he showed them the video of Bangkok where all were enjoying nicely in some nice place. He said, these are the people whom you are trusting and you want me to listen to these people. The point is, when it comes to personal gains, they don't care a damn. They just use and throw. That is the concept what builders follow. And we should also learn from them some things from this such type of things. Third thing, your agreement under any circumstances should always have an exit clause, termination clause. When you are talking with the builder, you have to say, I don't know any technical stuff. If I knew that thing, I would have been a builder. I would not have been a flat purchaser. I would have done my self-development. I only know the date of calendar. Tell me by which date I will get possession of my flat with building completion certificate. On that day, all your rights, lock, stock and barrel, you will be kicked out from here. They say, talk in terms of grace period. They say rent is X. After the stipulated period, there will be 0.10% increase in rent for say 1 year. Your question should be, what if after that grace period also you are not giving possession? He will say, now increase the rent by 20%. Okay, what next? Like that, in a very blunt tone, you have to talk that say 1 extension, 2 extension, 3 extension, whatever you feel appropriate. On that day, you will be kicked out from your lock, stock and barrel. A very innocent clause is there in the agreement that will appoint an arbitrator. Believe me friends, the fees of the arbitrator will be such that you have not even dreamt. Always have an arbitrator, a retired high court judge, so that the idea behind it, we are making it difficult for him to play with the things. And there has to be a specific clause that this money of arbitration will be deposited in advance by the builder and that will be paid from that by society. Normally builders, what they say, I will pay your lawyer's fees, I will pay your PMC fees, so that he is having a direct access with them. So what you have to do is, first you have to deposit those things at the time of development agreement with the society, and society will take a call on all these things. When you go to the builder for negotiation, you will say, I want marble flooring, accepted. Polished doors, accepted. So and so thing, accepted. There are 10,000 items in construction industry. You won't even know the name of 100 items. So whatever costing play he has to do, he will do it in the other things. So don't think that builder is ignorant or knows. He knows how to tackle an individual. So under any circumstances, my point is very simple. Development agreement has got to be watertight. Specific clauses, one clause, termination. Second clause, 10% lien on the property till building completion certificate is obtained and you are put in vacant peaceful possession of the flat. If these two clauses you are writing in your agreement, believe me, this will supersede most of your 99% of your clauses. These two clauses. And third aspect is the financial viability. For that, what you have to do, when a builder is coming, you have to insist upon him that right now he pays all the money to the corporation. What happens is they make payment in installments. And if for any reason, because the market scenario is such today that there is abundant stock, and the whole play of the builder is that rate will touch so much, and if that rate does not touch, you land in a soup. There are so many instances of abandoned projects which is not coming to light. In fact, I read it yesterday in newspaper. The best names of the industry, they have declared to RERA that we are not going to complete the projects. I am not naming a particular developer, but this is a fact. There was one of the best names who had recently come out with an IPO. He did not have the income tax number for a project where the flat costs were more than 5-10 crores. For car parking, the money was taken. The same builder, because my article was quoted in that, I am not naming, he says that railway station is coming next to my project. And just below his statement, the statement of paper is there, making a mention that the MMRDA municipal commissioner, he makes a categorical statement, we are not planning any station. My quote was also taken, and you can write down, you can do it in Google, bogus railway station by a builder, and you will get the name of the developer. So these I am talking of the best names of the industry in Bombay. These people can go to this extent. So you can imagine the extent which small developers are going through who are lacking in funds. The other golden rule which I would like to emphasize for you is, if the builder is telling you, I will complete the project in 3 years, don't give him a license for 3 years to remain calm. You have to insist on a bar chart. Every month what you are going to do, that we want a statistical analysis for you. Don't wait for the thing to come to an extent where it is about to get, all your rights will go away. You should know at the beginning stage itself. And please don't just go for area, because in my career I have seen cooperative societies don't think of anything else except area. This builder is offering X percentage, another builder is offering Y percentage. My humble request to you is, give some profit margin to the builder if that is in your own interest. The project should be viable for the builder. Otherwise, if you will compromise, for example, we are sitting here, some builder gives you more and there is leakage 24/7 water from the above thing. Then what will happen? You will be put to a lot of nuisance. Let me share with you some humorous definitions related to building industry. Builder, यानी बिल का कभी डर ही नहीं रहता है. Buyback, you buy from me and see my back. Leakage, there is a guarantee. Leakage तो आने वाला ही है. 24 hours water from tap or from wall, you will get it. Builder की सही पहचान माप में ही पाप है. TDR, total destruction and ruin of building. Of course, this is said with a sense of humor. It is not meant to be taken seriously. The point I am trying to make is very simple. Allow builder to earn some money. If you want your own safety, your passport to security is allowing the builder to earn something. Your proposal should be a reasonable one. To get a clear idea of the proposal to be reasonable one, in the first meeting itself, your PMC, you should take it in writing that what is the FSI, TDR, tidbit, whatever that is the maximum he can construct. That should be in writing. And a clause should be put in the agreement that builder will not construct anything more than dash square feet. And if he constructs, full amount will be received by us. Because builders never share these details. I mentioned to you 15 FSI. Many of you will not believe it, including architects. But that is a fact. In my Ghatkopar area, only 15 FSI is available. They cannot utilize that much FSI because of hindrances of open space deficiency, size of plot, etc. But we are fooled that very FSI is less. Earlier we were told 1 FSI, 1 TDR, 1.35 fungible FSI, fungible debt, and the capping was 2.70, 1.1 plus 1 plus 0.35 plus 0.35. But because of now all these technical terms being used, the road width, etc., there is an assertion from your side should be that specifically you have to mention about the FSI. Now coming to the selection of developers, you are first eliminating 50%, and those 50% will be your best friends who will share with you many things which you don't know about that property. That you should know how to make that your trump card. You have to give, one of your team has to give an impression to those builders, we will try and bring you back. You share with us how this is workable, how he is able to give so much, and why you cannot give. We have full faith in you. I want you to take up the project. Why, if he can give you, why he cannot do? So he will share with you the tricks of the trade. ये देखो ये ऐसा गलत करने का कोशिश करेगा, ये ऐसा गलत करने का कोशिश करेगा. Many times government records are manipulated and forged. The classic example of the same is Kalyan and Dombivali, those areas. So many RERA projects, bogus certificates were issued. And ultimately everyone knows it. It has come in newspaper, High Court inquiry, one architect exposed this fraud. And now all the websites of municipal corporations are linked with RERA. These are the directions given that within some time you have to link it, till that time you have to give it manually you have to supply. And all these FSI calculations, building having OC, bogus certificates were issued, and this went on for a long time. I can imagine one person can be a cheat, 2% can be a cheat. But if I am not mistaken, more than 35 cases RERA is detected. So you can imagine how many undetected cases might be there. The next stage, when it comes to redevelopment, the saddest part is the moment the word redevelopment comes now, our members start thinking how much is his flat, where is his area, what amenities he will do, what interior he will do. And at that time, many so-called people calling themselves PMC will come and say, we'll go for self-development. Believe me, friends, self-development is not at all easy. Have you ever wondered, if some bhai comes for protection money, do you think your society's secretary, treasurer or chairman is capable of tackling him? This is just one simple example, and we humorously call BMC as bachelors and masters of corruption. It is a known fact that so many wrong things are there in BMC. I am told that the municipal commissioner, which is sitting in his basement itself, that area is a record storage room. It is being used for office purpose, I am told. I am staying in Ghatkopar N Ward, and I invite everyone to come to Ghatkopar and see the N Ward office of BMC, just adjacent to Ghatkopar station. And a cursory look at that place will tell you that perhaps the fourth floor, the top floor of that building is illegal. BMC M Ward, M East Ward, M West Ward, there also I am told some unauthorized construction is there. A Ward, I am told some unauthorized construction is there. Why go forward? Just 1 kilometer from here is Mantralaya, not far away. Normally, every one of you, when you go to any building, if your flat is say on the 15th floor, will you walk up 1 floor? You will press the button for 15th floor, and 15th floor the lift will take you. But I invite you to go to Mantralaya. Our cooperative department hearings are held on the top floor, and we have to climb 1 floor and go. The BMC Mantralaya building itself, I am not an architect, I don't know whether that building top floor is legal or illegal. But I can vouch and make a statement before this house that for 1 floor we have to go by staircase, because I have gotten there at least 25 times walking 1 floor. We cannot go on top floor directly. It was constructed later. That is what is there. So what I am trying to make a point is, everything which we take it for granted. I am told that 50% of the properties in Bombay do not have an occupation certificate. 50%, not 5-10%. Classic example. Some of you might be residing at Tilak Nagar. Is there anyone present here from Tilak Nagar? Doesn't matter. You can ask anyone residing in Tilak Nagar, has their building of a whole colony received OC? Only 2 or 3 buildings have got OC for the whole of Tilak Nagar complex, which consists of more than, according to me, more than 75-80 buildings. And this is also constructed more than 15-20 years ago. This whole thing, Tilak Nagar, like this, there are so many complexes. These are all the government already being developed. It's MADA property. Tilak Nagar, I am making a categorical statement here before this thing, which is recorded, and our friends in BMC, MADA, anyone can challenge me on this point, that hardly 3 or 4 buildings in Tilak Nagar have got OC. Rest all the buildings don't have OC. So, in my opinion, 50% of the properties in Bombay don't have the occupation certificate. In New Bombay, recently a petition was filed, and their corporation makes a very bold statement that we don't have any records of the buildings which don't have an OC. This is the directions given by the High Court. I have got those papers. I can show it to anyone who wants to see. Then directions are issued by the Bombay High Court that you compile all these things and keep it on record and give it to the complainant. So, for a small change in our flat, BMC officers with like Alsatian dogs come running and say this is wrong, that is wrong. But what about the bulk of the things? One BMC official was telling, even if my boss tells me to go in the slums for unauthorized construction, I flatly refuse him. Maar khane ko mere ko nahi jane ka hai. You look at slum buildings, ground floor was permitted, then first floor came, and many buildings have 2 floors, which are all, substantial number of them may not be having the permissions. But that is the way of life. Now coming back to our redevelopment specific things. Please don't go for the submissions being made by the builder of stack parking. That will only be used for drying your clothes and 24/7 WWF with your neighbor. Because if you happen to have a parking on the first floor of that stack, obviously you have to wait every day for the lower person to remove the car. Sometimes he may not be in Bombay also. He will just park his car, won't give the key and go away. And even if the key is given to the watchman, there will be a complaint that today mere gaadi mein se ye chori ho gaya. Second thing, over a span of time, you will see that these stacks require a very hefty amount of maintenance. Number one, from day one, you have to keep some extra staff for that. Plus, you require special skills to take out a car from stack, because there is quite a big probability that your car will get spoiled, the tires, etc. every now and then. I have seen many stacks where people are not bothered, society is not bothered of maintaining the stack, because that comes, the cost involved is high. So society says, why should I maintain that stack? It's not that supposing if there are 25 stacks, all 25 will be spoiled on same day. Abhi ek do stacks, when they are not working, the society does not bother, and those members have to suffer. So stack parking in your commitment, accept some less area, but please don't invite professionals like us to earn and do more WWF at your expense. That is my humble request. Don't go for things which is going to give good business to lawyers in the days to come. Your peace, patience and smile is more important. अपनी जीत में भी अपनी हार है और अपनी हार में भी अपनी जीत है. Be generous to the builder. On one hand, I never hesitate in criticizing a builder, but simultaneously I personally hold the view, in your own safety, allow builders to earn. Otherwise, you will spoil the sleep of yours. Every day when you come to your neighbor's face, instead of smiling, you have to frown, because your legal injury is either caused to you or to him. And for what? For the sake of a few square feet in redevelopment. Please don't make this mistake. Second thing is, many times they say tower parking. Has it ever occurred to you that even if you go for tower parking, you have to bring the vehicle down for cleaning? Abroad, the condition is very good, roads, and there is less mud, and everything is much nicely maintained. But that is not the case here. Here, even if you drive 10 kilometers, your car will be such that it may require some cleaning. So that thing you have to take into consideration, and this will have a special impact when you are going for tower parking. Now new concepts are coming like charging of vehicles. There, charging also, many fires are occurring, you know it. There should be some specifically designated spots for charging. We know government officers are very eager to help builders lobby. But you have to see your safety also. So whenever you are going for redevelopment, you have to insist upon the developer that the charging space will be at a different place compared to the other cars, so that in the event of a fire, there is less damage. These things are new, and these are novel concepts, but which certainly we will have to face and move ahead with the times. So these types of things have got to be taken into consideration. Now let us touch the aspect of GST. GST we think is good night, sweet dreams, take care. But believe me friends, GST is a very big bone of contention. Builder won't speak more, but when it comes to giving possession to you, he will say, now give me GST amount. Same is the case in rental premises going for redevelopment. The area, additional areas, etc., there also it will be a big, huge amount will be there, 5%. Now how is this 5% amount arrived for GST? That is also a story. GST is actually 7.5%. You will say every time we are looking it is called 5% and not 7.5%, and what are you talking? GST, goods and service tax. Any property which is being redeveloped involves a land aspect plus construction aspect. On land they cannot levy GST. So to cut short their work, what the GST department says, we presume 1/3 is the cost of land, and as abatement out of 7.5%, 1/3, which works out to 2.5%, we are giving you an abatement, and so builders charge 5%. Now pausing here for a moment, if you look at land, the prices are very high in a city like Bombay. But if you go interior, some 100 kilometers away from Bombay, there the cost of land is peanuts. How can you equate both the same cost of land? He also gets 1/3 abatement and you also get 1/3 abatement. Various high courts of Bombay have taken a view that the policy taken by the GST department is not correct. Gujarat High Court judgment is there, and some from South India, some High Court judgments are there. This saying it is blatantly illegal and that is not the correct stand. But what is the view of the GST department? Very simple. I happen to be, one GST commissioner was my friend, so I casually off the record asked him, yes sir, this is my submissions and these are High Court judgments are there. I request you to advise me because I also got a few flats and which are under redevelopment. So what he told me, Vinod, as far as I am concerned, sitting in a chair, I will recover GST from you. Your point is valid. You pay under protest and go to Supreme Court, get us an order from the Supreme Court and we will accept it. Very simple. Revenue person's approach is very clear. I want GST at 5%. This is my instructions. So if builders lobby devotes some time to correct such anomalies, then the individual flat purchaser stands to gain. But builders lobby is only interested in that thing, what is affecting them. Now as a flat purchaser, even if you are convinced by my submission, the cost of going for this litigation is much more than the 2.5% or whatever, that 7.5% or 5% GST is there. So knowing certain things are wrong, we have to accept it. I'll give one more example. Maharashtra Ownership Flats Act is there for the state of Maharashtra. Each state has got their own Ownership Flats Act. When these enactments were done, Ownership Flats Act, in Maharashtra we got it in the year 1964. Similarly, after independence, all states got their own Independent Ownership Flats Act. At that point of time, RERA was not in existence. So we had individual state acts. Recently, one such petition went to Supreme Court. It was pertaining to West Bengal. It is called Hirwa something. In that petition, Supreme Court has said that this Ownership Flats Act is illegal. And this has to be scrapped. So West Bengal Ownership Flats Act is scrapped. As far as other states acts are concerned, including Maharashtra Ownership Flats Act, it was not operational for a few months. Again it is made operational. Maharashtra Ownership Flats Act, because of the repealing provision, it is a temporary piece of temporary legislation. Every 5 years isko dhakke marte, just as elections come and go. Every now a push is given and it is extended by 5 years. For some time it was not applicable, MOFA, but now again it is applicable because of the amendments. So, as a flat purchaser, I am trying to tell you, the right course for you is to file your complaints in MOFA today before MOFA gets scrapped or repealed. RERA, as we know, in my view, is a toothless act. Reason for the same is, in RERA, they are making it things difficult for the purchasers to ventilate their grievances. They say, you go to the conciliation officer, so another 6 months goes there. And what is the need of conciliation? And presuming you want conciliation, why can't both the proceedings go together? If one day prior to your order, if some compromises occur, you can always file a consentum and get the matter resolved. But the approach, in my view, of the government authorities, RERA, which is an open secret, is They want the project to be completed. They say, ये जो भी बिल्डर ने किया है बराबर नहीं है, वो बाद में ले लो, पहला प्रोजेक्ट कंप्लीट करने दो. And as we know, builders are smart enough to execute a company LLP with a limited liability partnership. The amount that will be there will be peanuts. If you look at some prominent builders, the name is of the prominent builders, but the persons who are the directors of their company, sometimes they are staying at very far off places like Mira Road, Dombivali, Virar, etc. I am not saying that those persons are not up to the mark. What I am trying to make a point is, the brand name is one thing which attracts our eyes, and we expect certain standards when the flat's costs are in crores. And the probability is the director of that company's flat might not even be 25% of the cost of the flat which he is selling. So tomorrow, even if that liability is coming, it will come on a person who does not have any money. If you call him like an international fakir, it will not be wrong. Look at brand names which have come, they have declared in today's paper only, I think it is that today or yesterday's paper. The best of the brand names of Bombay, they have said that we are not going to complete the project. Now, when you as a flat purchaser are there, your society is going for redevelopment. The first dialogue that comes is, don't worry, builder will get the conveyance. I fail to understand, your society has been constructed 25-30 years ago. Why you have not got the conveyance? And is the managing committee boasting that builder is going to get the conveyance? That is your obligation. And why you are not complying with your obligation? One member can force the society to get the conveyance, and we have filed petition for one member directing that the present managing committee is in collusion with the builder and direction should be issued for getting the conveyance. And the best way is to put a court receiver. We have to make a prayer for the appointment of a court receiver on the flat of the managing committee members, as they have failed to comply with their duties. Now, by the time that matter will reach the board, at that time 90% you also won't be interested and he also won't be interested. But in law, specifically criminal law, the procedure is more than the punishment. That constant fear that my flat is under risk, I am not able to create third-party rights, I am not able to take bank loan. These things push up and the matter receives attention which was not receiving till date. You will be surprised to know that for getting conveyance, your signature is not at all required as a cooperative society. The law is crystal clear, Supreme Court judgments are there, that for obtaining conveyance, you don't have to sign the papers. What builders try to do is, they ask from so many information from you in the name of conveyance. When he is signing the agreement with you, anything and everything is with him. Document is registered, it is a public document. So you have to tell the builder, you have signed the document, you have got everything. If at all you don't have, go to the registration office and get all those documents, because all these are public documents, anyone can get it. Why the law has kept a period of 4 months for obtaining conveyance? One of the reasons could be that in a cooperative society, we cannot transfer the shares for a period of 1 year. The intention behind is to protect the interest. Supposing tomorrow there is some collusion between the outgoing member, incoming member or the society, the legal heirs of the property gets some time to ventilate their grievances. So that is the reason why for 1 year the flat cannot be transferred. That is the law provision. If the builder has not executed the conveyance within a period of 4 months, you have to insist to the court that it is he who will pay the additional stamp duty. Stamp duty, as we know, every year the ready reckoner rates are there. And if all the documents are registered and the document is immediately, it goes for this, for conveyance, the stamp duty is only 100 rupees. Now, because of that, it will be 500 rupees being the minimum value. But if there is some balance FSI, balance TDR, that will also be counted to the potential and stamp duty will be recovered on the said amount, irrespective of the fact whether you have utilized that FSI or not. Over a span of time, this FSI and TDR increases, and that is the reason why many of you are told that you will have to pay a huge amount towards stamp duty. So this is one point which you have to keep in mind, and straightway, in my opinion, file a criminal case against the builder. You don't have to take a good advocate. A reasonably young advocate also you take and file it, because what happens is, when you file a criminal case, Arguments and all those things will come after 3-4 years minimum. So by that time he does not know who is that advocate or what is his brand. All those things at that point of time you can appoint a good counsel and he can take care of that thing. In between stage, 99% there will be a compromise. Why I say there will be a compromise? Because the law stipulates that if the builder is convicted, then he cannot carry out construction activities. That is the law. Builders don't bother about anything else, but if they are not allowed to carry out their construction activity, that will be a very big deterrent to them. And they know that public now, they have got short memory. What is talked today, in a few days they will forget it. And that's what they fully exploit. So when you are firm, when you have filed a criminal case against the builder, FIR is filed, you will see the difference in his approach towards you. But someone has to take a lead. You don't expect the secretary to do all these things. Secondly, as a cooperative society, it is limited is the last word. So you are within your rights to appoint a paid employee for doing all this running about. If there is some retired member in the society or retired person, I would say, he may be a family member or anyone, he will have some interest, love, affection for the society. Pay him something and let him go and visit the court on every court date. Don't trust lawyers, my first word. Because many times, either knowingly or unknowingly, or because of their other commitments, they may not go to the court. Always have one of your representatives to supervise the work being done by the lawyer. So at least your person goes and stands in the court that my lawyer is busy, please give us the next date. Sometimes cases are disposed of because of the absence of the parties, for which you may have to pay a heavy price. So one member from the society or one of the occupants of the building should always go on the court date. In my view, you should form a pressure group. We have luckily internet, social media. So the smallest amount of injury which is caused to you in terms of occupation, not giving audited statement of accounts, not giving building completion certificate, in an unbiased way, present it on social media. You will say that everyone in Bombay knows that this builder has not given. Why you want to put it on social media? My submission is, many times flats are booked by NRI. Many times flats are booked by a person who is many kilometers away from here. So he has no idea or access to the things that are happening in Bombay. He just trusts his broker or a few limited people. But whenever he sees something about a particular builder, he may tell his relative or friend, by you give me a good builder and these are the reports coming of this builder. So the media is so powerful, but the problem is we don't know how to use the media. That is a real problem. You are armed with so many things. Let me share with you one of my own experiences of using Right to Information Act. Afzal is specializing therein. My one client came to me stating that for 30 years he has not got the document from the stamp office. 30 years. And he came to me. So I safely presume that if I go and bang my head against the wall, nothing is going to come out. What I did, a simple one-page RTI filed with handwritten, 10 rupee court fee stamp affixed and given to the government authorities. That is the Bombay collector and the IGR at Pune. As usual, perhaps in a dustbin that application of mine went. Perhaps. I did not hear anything for 45 days. So what I did, instead of even visiting the stamp office, I did not do anything. I just filed a petition in Bandra because I stay at Ghatkopar. My son filed that petition. At that time he was not even an advocate. I filed a petition. And what stand I took? I said I have paid 10 rupees court fee. Because I have paid 10 rupees as court fee, I am a consumer within the meaning of Consumer Protection Act. And this act is an act of deficiency of service and unfair trade practice. And through one of my friends, I conveyed it to the stamp authorities. Adv Sampat is a very small person. But he has got friends in Chennai, Assam, Bengal, and they are expert in making application in the local places in local language. So that your officer may get an opportunity to visit some other places apart from Bombay. Here, This application I had made the PA at the, Pune, because stamp office, central government is this. So at stamp office Pune, I made that person a party. And within 21 days, sorry, I got a reply from them that तुमच्या काम त्वरित गतीने करून दिलेलं आहे, तुम्ही स्टॅम्प ऑफिसमध्ये येऊन डॉक्युमेंट घेऊन जावा. No, I have not even attended those hearing after that day at consumer court. But sometimes the way you present yourself is important. Let me share with you another example. One builder was not giving me conveyance, and as usual I tell my clients, don't write conveyance not received. If you are writing any letter to a government authority, I am sharing with you one or two of my tricks, my tips with you. If you write a letter, there is small leakage in my flat, the chances are that letter will go in a waste paper basket. But same letter, you begin with the facts, highlighting, screaming rather, not highlighting, screaming of the facts, that there are 50 flats in my building. Each flat costs 2 crores. So the total value of this project is 200 crores. And I apprehend irregularities in a project of 200 crores. When this letter goes to a police officer, which word will catch his eye? I leave it for you to guess. Same way when this letter goes to Deputy Registrar of Cooperative Society. Same way when this one letter goes to BMC official. And always make it a point to write a letter to multiple people, from Chief Minister, Chief Secretary, Anti-Corruption Bureau, and so many multiple people. You feel this person can be my savior, address a letter to him. You may write a post it by registered AD or an ordinary post, I leave it up to you. Or even if you don't post that letter, that I leave it up to you. But the point is, the first 2-3 pages will show the number of people to whom you are posting the letter, addressing the things. So the letter which is going will carry a chain reaction. How? Once you have written this letter, every 15 days send one RTI. Sitting from your own office without visiting anywhere, just send RTI, action taken on my letter dated so and so. And ask some few other delicate questions, like supposing my application is of 1st January 2024. Which all matters after 1st January 2024 have been sorted out? Which all matters are taken up on a priority of basis within 1 week? Ask for orders passed by the officer pertaining to redevelopment, 79A orders in the particular ward in the last 3 years. So that type of data questions, when it comes now, they will find that this application is a nuisance creator. They may have that impression. And sometimes officials, when such types of questions are asked, they try to get these things. I will give you one more tip. Whenever you face a problem, these are election days, so please tell your local MLA to raise the question as a legislative assembly question in assembly. If you know your MLA, he has a right to raise your question as an MLA, Vidhan Sabha, Vidhan Parishad. And when anything becomes an LAQ, Legislative Assembly question, evasive things go away. Now today you are talking with a very junior officer. But the moment it becomes a Legislative Assembly question, the matter goes to the Principal Secretary. And Principal Secretary supervises it. So they always have a tendency, isko clear karo jaldi. There are certain things in government where automatically, without speaking, it is conveyed, without speaking. This is how many things are there in bureaucracy which are said but yet not said, and yet not said yet done. So when you are putting up the things, you should know how to present your facts. For example, BMC. If you are writing any letter to BMC, specifically in the western suburbs, you ask them how many files of yours are lost files. How many building proposal files are lost? How many plans are not traceable? And then you ask your other questions. There is a possibility that you may get a better response than what was desired. So, how you are presenting your things. Now, coming back to our redevelopment topic, you have to find out what are the gains and the losses to you. One such thing is income tax. What will be the income tax on various amounts being received by you in your personal name as well as that? You put a clause in the agreement itself, what should be what will be builder's liability for income tax. For example, you are getting certain money. What about it? Whether it is taxable or not? Builder will say, no, my CA is saying it is not taxable. Don't worry about it. Like if it is not taxable, write it in the agreement. If it is taxable, pay it, simple. So both ways, heads I win, tails I lose. That is how firmly you have to talk. Another thing which I see most of the society is failing is, whenever a member approaches them, they say, I want to take a loan, and generously societies give them the NOC required. You as a society should think twice before giving NOC. You have to specifically mention that in the event society is going for redevelopment, then at that point of time, the society will have an unconditional right on the flat and the building will have to be demolished, for which we have the NOC from the incoming member as well as from the banks. Many times banks, what they do, they say, you clear my loan, then only we'll give NOC for redevelopment. Or else, supposing my loan is of 60 lakhs, you get me some funds for 60 lakhs or another flat from worth 60 lakhs on which my mortgage should remain. So these types of things are not anticipated when you talk of redevelopment. For the sake of one member, other members have to suffer. Same is the case with wine shops. If your society is having a wine shop, that wine shop license to transfer it is very, very difficult. And we have seen redevelopment proposals where wine shop remains at the same place even when the full building is getting demolished except that wine shop. It is just next to my house only, Vikrant building, just in Katkopar East. They could not, they entered into some transaction, whatever it may be, I am not bothered. But the building now has come up probably 20-storied, but the wine shop is there intact. Afterwards, what adjustment they do, they do, it's a different thing. But when in your building, if there is a wine shop or etc., you have to be extra cautious because that will create a lot of problems for you. The licenses are very costly of wine shop, and even a transfer from one place to neighboring place is not easy and it involves huge funds. So, in redevelopment, this has to be taken into consideration. The height factor I emphasize to you, income tax obligations are already explained to you. The agreement clauses which you feel are in your favor, they should always commence with the word notwithstanding anything contained to the contrary. Because if any submission is made with the concept, with the beginning words, operative word, notwithstanding anything contained to the contrary, it is a superior clause which has more weightage and value. So that is very important. As I told you, we should know the perfect availability of the particular project and FSI of the project. So when you are taking out a tender, the clause in the tender itself should be the feasibility that is being done by the developer, and the FSI intimation we are giving it should be rechecked and reconfirmed by the builder. Always execute redevelopment agreement on as-is, where-is basis. Never make the mistake of accepting the submission of the other party. ये लड़की है, शादी करनी है तो करो, वरना दूसरे मुहूर्त हाजिर है. This is the policy which you should adopt. Don't go for any guarantee with regards to title. Let me illustrate the same to you with example. Many buildings are there situated at Goregaon or Mulund, which are coming under the purview of the Forest Act. After 50 years, government woke up and said that these are forest land, and so many best of the solicitors have given title that this is clear and marketable title. Tomorrow anything comes up in there, you will come in a trouble. As an office bearer, you have got very much limited knowledge of property matters. So don't take any responsibility on your head. Otherwise, straightway a court receiver will be handing this thing on your flat. One more thing which 99% of the members take it very lightly. Supposing my building is going for redevelopment, and when my building is going for redevelopment, if the builder is not a honest builder willing to comply with his terms, conditions, rules, regulations which are followed out and committed, the new flat purchaser can recover the money from you. That is the law. Who is the builder? He is the power of attorney and agent of the society. But who is the principal? Principal is the society. Your agreement may have a clause that the dealing is on a principal to principal basis, but court stand is very clear. The builder is getting some power from the society and is acting as an agent of the builder, of the society. So, prima facie, the situation is such that tomorrow, if the builder has sold something, he fails to complete his liabilities, he has taken money from so many people, and he says, tomorrow I am not doing this thing. The purchaser will first approach the builder. Builder's company will be hardly a 1 lakh rupees, 2 lakh limit, 2 lakh rupees, because it is a limited liability partnership. Nothing happens to the builder because that limit is crossed, he won't invest further. But you are the owners of the property, which is in crores of rupees. So he can easily recover that money from you. For your flat, for example, your flat is of 5 crores. You are only issued a share certificate of 500 rupees. And on the basis of that share certificate, you get a right to use and occupy the property. The property always belongs to the society. Societies are of two types: open plot and plot owners. Open plot and flat owners. In flat owner society, 95% of the people are staying because there the privacy of contract is with the builder who has sold the thing, constructed the building, and in open plot, members themselves construct. So please don't take selection of builder on a light footing. If he is not a proper person, you will have to shell out lakhs and lakhs of rupees from your pocket. And there are so many judgments on this. Vaidhi Akash judgment is there. First developer sold, grabbed the pocketed the money. Then second developer came. Second developer and the society said, we don't have any contract with you. We have contracted, you had contract with the first developer, go to the first developer. And court said nothing doing. It is on a principal to principal basis. And the flat purchasers who had booked for the first flat with the first developer, the society was held liable, the new developer was also held liable. But the point is, you as a cooperative society members with limited knowledge are literally ignorant of all these facts. So you have to be very, very cautious with regards to selection of a developer. Other thing in redevelopment is, today you are aware, it may take 2 years, 3 years, 5 years or more years. Please insist on your members to have a nomination form executed. There are instances where there are some disputes amongst the family members. And in that scenario, probate letter of administration comes and the developer stops himself, puts his foot down, he says, I will give the possession to the person who brings a court order. Even rents are stopped. So please take as much precaution as possible during this particular stage. And as I mentioned to you, nomination form, there has to be a clause in the agreement that if something happens to a member, then possession of the flat will be given to so and all benefits has to given to the say legal heir, which very rarely a developer talks, and even society people are not aware of these things. So when drafting an agreement, all these things play a very vital role. As far as cooperative societies are concerned, we talk of bylaws. It is by to law. Baila sarka manus hai. And in reality, it is not bylaw, but it is bylaw. Supreme Court has time and again held the view that bylaws do not have the force of law. Just because something is written in the bylaws, don't think that it is the gospel truth. Bylaws do not have the force of law. In a cooperative society, many activities are permitted. For example, as a businessman, I quote my fees on telephone. That does not make the flat a commercial use of the flat. If, as a member, I am giving tuitions, I am an advocate having an office, all these activities are permitted in a cooperative society. It is not called commercial use. Beauty parlor, tailoring classes, so all these things are permitted. Cooperative society cannot recover dues prior to its formation. You have to be extra cautious when it comes to amalgamation of properties. There are also stamp duties involved. So when a builder is doing multiple plots are there, he is amalgamating. So on that, you have to insist for payment of stamp duty. Society cannot recover dues prior to its formation. You should not spoil relations with members for the sake of money. If a member is not paying money, what is the amount not paid? 1 lakh, 2 lakh, 5 lakhs, 10 lakhs. Compare it with the value of flat. Today, banking rate is 6%, 7%. And if you are a defaulter, society has a right to recover 21% interest from you. So unless the amount crosses more than 50%, I will advise you not to have any disputes with the defaulting member, because your money is literally safe. It is like it being a mortgage for you. So you don't have to worry much for that money point of view. And tomorrow when his legal he expires, his legal has will be the first person to bring the money to you without even asking for it. I think I have spoken a few words on conveyance and redevelopment of property. I am thankful to the organizers for giving me time to express my view. I am thankful to all of you also. Thank you, friends.